All right, let's talk about really, I call it the third biggest mistake, and it's probably not so much your mistake. If you are the client, it's the mistake of the attorney who drafted it, not pushing you far enough to answer questions. Or if you did it out online, then yeah, it would be your mistake. And that is that the trust is poorly written. So this trust is going to control during your lifetime and after your death, because it's going to say where your assets go. A trust on your death can either kind of just end and all the assets go outright to your beneficiaries, or you can set up your trust to continue for that next person. So sometimes couples will have, a joint trust, and when the first spouse dies, their assets then will go in and create a new trust within the first trust, and it's called, now it becomes irrevocable. So it'll be for the benefit of the surviving spouse, for example, and the surviving spouse can even be the trustee, but upon the death of the surviving spouse, those assets will go where that first spouse wanted them to go. So that's the reason it's an irrevocable trust. The surviving spouse really can't change the direction. Revocable living trust will split in half on the death of the first spouse. It will go, the surviving spouse will still have a revocable trust they manage, and the deceased spouses will become an irrevocable trust that the surviving spouse can be the trustee of, typically. Lots of times people don't think through the consequences of the what happens next. And this is what I mean by poorly written trust. So sometimes what we see is it says, okay, when both of us are gone, it's going to go down to the kids. And then it might not say, does it go to, if one of the kids dies, does it go to the surviving kids, or does it go down to the deceased kids' children, the grandchildren? So you have to think through that. And especially if you're not naming family members, but you're naming friends, or you're naming somebody else where it's not so logical. If you'd want to go to the survivors if somebody dies, or down to the kids, you want to say, what happens if this beneficiary does not survive? Does it lapse the gift, or what happens? And a lot of times people don't think through the what ifs, especially if they're doing their own online form, because it isn't something that you would think about every day. What if this happens? What if that happens? So thinking through in detail. See, one of the things that makes an estate plan good and makes it work is that you don't leave things to chance. You don't leave things ambiguous. You're very clear about what happens if. And so one of the problems with trusts and any other estate planning document is if it isn't drafted with that crystal clarity, that leaves an opportunity for people to complain or to litigate or for all sorts of problems. So do make sure that all the what ifs have been drafted in the trust and that we know where assets are going to go. Along those same lines, think through the what ifs. What if you are the trustee and maybe your spouse is the trustee? Who's the next in line trustee? You always have to anticipate, what if you and your spouse both are in a car accident and neither one of you can act as a trustee? You need to name successor trustees, and you want to go at least 2-3 levels deep beyond yourself. So you want to be able to say, okay, if I can't be the trustee, my spouse can't, then maybe it's my child. If that child can't, and you might say, well, then my child's spouse, well, remember, something could happen to both of them. Go another level deep. You can always name a professional to be the successor trustee. Just keep in mind that most professional trustees have a minimum investment amount that otherwise they won't serve, and typically that's at least $500,000 in liquid assets. So think through all of those details. Make sure the trust clearly reflects your wishes and doesn't have any ambiguities.